Hi, everyone. Good evening. I know people are still streaming in, but wanted to welcome you and to our Know Your Rights presentation. Wanted to thank the Asian American Bar Association of the Greater Bay Area and API Legal Outreach for hosting this, along with Cal-APABA, or the California Asian Pacific American Bar Association. Deep appreciation to the 600 of you who registered for Cal-APABA's APAs versus Hate conference. My name is Charles Jung. I'm the Public Affairs Co-Chair for ABA, or the Asian American Bar Association of the Greater Bay Area. Also serve as the Executive Director for Cal-APABA. To start, I'd like to recognize our various generous sponsors, including ABBA, also Davis Wright Tremaine, the Dolan Law Firm, Hanson Bridget LLP, Morgan Lewis, Procopio, Squire Patton Boggs, Wilkie Farr and Gallagher, and Zeftrina Perez. And thanks also to our generous donors, ORIC and the Northern California chapter of the Iranian American Bar Association, and our individual donors. And deep appreciation to our 29 community co-sponsors for their support and allyship. So the purpose of the APAs versus Hate conference is to both provide what we hope is useful information, but then also to inspire action. So for those of you in the audience who are attorneys, and if you're willing to serve as a legal referral for victims of hate incidents or hate crimes, you can sign up at bit.ly/APAs versus Hate. I'll put that in the chat. And if you're able to support this work financially, 100% of our proceeds will go to Stop API Hate and API Legal Outreach. And I'll also put that link in the chat. It's bit.ly/Cal-APABA. So without further delay, I'm so proud to introduce our moderator for this evening, Mari Bandoma Cayado. Mari is a trial attorney at the Dolan Law Firm. She exclusively represents workers and plaintiffs from many different industries against employers in wrongful termination, discrimination, harassment, and retaliation cases, as well as in human trafficking cases. Mari is the president of the Filipino American Bar Association of Northern California. She also serves as the co-chair of the Asian American Bar Association's Civil Rights Committee, and she helps lead Cal-APABA's Hate Crimes Task Force. Mari?
Thanks so much, Charles. It's my pleasure to be moderating this panel and introducing our speakers this evening. But before I do that, I would just like to point out that there will be an opportunity to ask our speakers questions at the end of the presentation. So please make sure to post your questions in the Q&A section of Zoom instead of just in the chat, because if you type it in the chat, it's easy to get lost in there because there's a lot of comments. So please make sure to type it in there. Our first speaker is Adrian Gidaya Rojas. Adrian will be speaking on navigating the criminal justice system and victims' rights. Adrian is a partner and the firm's lead trial attorney at Rojas Law, APC, in Torrance, California. He handles all aspects and stages of high conflict, family law disputes, mediation, and restraining orders. Adrian also represents the victims of hate incidents and hate crimes in criminal court as a pro bono victims' rights attorney under Marcy's Law. Prior to Rojas Law APC, Adrian was a veteran deputy district attorney with the Los Angeles County District Attorney's Office from 2007 to 2020, where he was a member of the Victim Impact Program and the office's Elite Sex Crimes Division. Our second speaker is Michael Ching. Michael will be speaking on schools and students' rights. Michael is a federal government civil rights education enforcement attorney at the U.S. Department of Education. He is also a lecturer at UC Berkeley, where he teaches ethnic studies and legal studies courses. He's also an adjunct professor of law at UC Hastings. Michael was previously a state assistant inspector general, and he currently serves as a commissioner with Berkeley's Police Review Commission and on National Employee Engagement and Diversity and Inclusion Committees at the U.S. Department of Education. Our third speaker is Brandon Butler. Brandon is the Assistant Deputy Director of Education and Outreach for the California Department of Fair Employment and Housing, or the DFEH. Prior to joining the DFEH in 2019, Brandon was a senior attorney of the Fair Housing Center of the Legal Aid Society of San Diego, Inc., where for 9 years he was instrumental in creating the first Fair Housing Services program at LASSD that provides education, outreach, testing, and enforcement of fair housing laws. Brandon began his career as a housing advocate at Communities Actively Living Independent and Free, a disability rights organization in downtown LA, where he advocated for housing rights for persons with disabilities. Today, Brandon will be speaking on housing, retail, and public accommodations. We are very fortunate to have two panelists who will be speaking on employment issues. First, we have Bill Tamayo. Bill is the District Director of the Equal Employment Opportunity Commission, San Francisco District. In this role, Bill oversees investigations and operations and issue findings of discrimination for the EEOC, covering Northern California, Northern Nevada, Oregon, Washington, Alaska, Idaho, and Montana. Prior to his role as District Director, he served as EEOC Regional Attorney for 20 years, directing the district's litigation. And before the EEOC, Bill was Staff Attorney and the Managing Attorney for the Asian Law Caucus. And last but not the least, Tony Jaramillo is the founder and principal of Tony Jaramillo PC. Tony is an employment attorney exclusively representing workers in harassment and discrimination litigation for 27 years. She has successfully litigated hundreds of cases of employment claims, resulting in millions of dollars in settlements and verdicts. She has extensive experience in both state and federal courts and has successfully argued before the California Court of Appeal. In addition to practicing employment law, Tony is a frequent speaker at educational programs and radio shows and recognized as an employment law expert on various employment law topics, including legislation spurred by the Me Too movement. Thank you to our subject matter experts for being with us this evening and educating us on what constitutes a hate crime, what government or other resources are available to victims of hate incidents, and what recourse victims might have. I will now pass it on to our first speaker, Adrian Rojas.
Thank you, Mari, for the introduction into Cal-APABA and the organizers for tonight's event, for having me as a panelist here tonight. So here we are over a year into the pandemic, and unfortunately we are seeing a continuing increase in hate incidents and hate crimes. And they're not new. Obviously, hate incidents and hate crimes are not new, but over the past year, we've seen a shocking increase on the news and on social media, especially as it relates to the AAPI communities. And I've seen enough of these hate incidents and hate crimes on social media and on the news, and there's usually a couple of commonalities that I see when I see these incidents on social media and on the news. The first common factor is that it happens in a public area, either on a bus, on a sidewalk, or on a street corner. And the second common factor is that there are people either watching or videotaping the incident turn into a hate crime as it happens. And when we see these posts on social media or on the news, our reactions are probably similar. We would probably say that's horrible, or I would have fought back, or I would have intervened, or if you're like my wife, if you've ever met her, she would probably, that she'd probably say I would have pepper sprayed that punk and I would have beat the crap out of that punk, followed by more bad words. And I realized that she reacts that way because she's also a lawyer, and she has a basic understanding of self-defense laws, and she's just naturally a feisty person. So, but to the average layperson who's standing on the sidelines as these hate incidents turn into hate crimes and hate-based attacks, I'm pretty sure that they're wondering, what can I do to protect myself? What can I do to protect that person who's being attacked or victimized? And is the law on my side if I choose to do something? Mari, you can move on to the next slide. Most of us have seen the March 17th incident video involving Ms. Shea. She's the 76-year-old woman who was attacked on the street corner on Market Street in San Francisco. And we saw how she fought back and defended herself. Next slide, please, Martin. We also saw Miss Vilma Carey. She was attacked on March 30th on a sidewalk on West 43rd Street in New York, and two doormen stood watching a few feet away from the incident as it was unfolding. And next slide, please, Mara. And just last week, on April 13th, we saw another attack on the streets of Upper East Side in Manhattan. In this scenario, we saw a Good Samaritan intervene, and several other doctors say you're ever in this situation, but what are your basic general rights under the law, and what does a prosecutor look at in determining if you're acting in self-defense or in lawful defensive?
Hey, Adrian, your audio is cutting in and out a little bit. Oh, we can't hear you right now. No, unfortunately not. No. I'm not sure what happened because we could hear you earlier.
Adrian, are you there? Can you hear me?
I'm here. I'm talking. I don't know if you can hear me.
There you go. We can hear you a little bit better.
Okay. Can I get the next slide, Mari? Now, under California law, if I'm cutting out, just go ahead and interrupt me, okay? If I'm under California law, you have the basic right to defend yourself, and that right also exists and extends when you want to defend other individuals. Under normal circumstances outside of the context of self-defense, if you use force or deadly force on someone, then you could be criminally liable, and charges would be brought against you by a prosecuting agency, normally the city attorney or the district attorney. But if you acted in lawful self-defense, then obviously you wouldn't be liable for a crime, and that would be a complete defense to any charges brought against you. Now, of course, that begs the question of what is quote unquote lawful, what is legitimate, and what is reasonable under California law. And I'll take the next slide, Mari. Unfortunately, the self-defense law is very technical, but the general rule is that you're allowed to use force in self-defense when you reasonably believe that you or another person is in imminent danger of physical harm, and that the use of force is necessary to stop the danger. And this can be broken into 3 separate requirements. And under the law, all of these requirements must be met in order for your actions to be justifiable and legal in self-defense. The first element is that you reasonably believe that you or someone else was in imminent danger of suffering bodily injury or imminent danger of being touched unlawfully. I'll take the next slide, Mari. And the next element is that you reasonably believe that the immediate use of force was necessary to defend against the danger. And I'll take the next slide, Mari. And third, you use no more force than was reasonably necessary to defend against that danger. Now, what does this all mean? When looking at the facts, the prosecutor is going to look at whether or not you were actually in imminent danger. And that basically means that there was an immediate threat or an immediate harm that you were facing. And let's take the case of Miss Shea. She was standing on the street corner and she was punched in the face and she was unprovoked. And if she responded with a wooden stick and defended herself against the assailant, and just as she did, she would be justified in defending herself because the attack was immediate and any future threats of physical violence was imminent unless she acted to protect herself. And the law will also look at whether Ms. Shea reasonably believed that a threat actually existed. Well, in that scenario, it was obvious through the video that the threat did exist and continued to exist even as the assailant was on the ground. And the law will also look into the degree of force that you use. And of course, this is where it gets tricky because what is reasonable, right? What is reasonable under the law? And the general rule is that the force that you use to protect yourself or others must be proportional to the threat of harm that you are facing or the threat of harm that the other person is facing. So for example, if someone came up to me and said, go back to where you came from, and sucker punched me once on the face, if I responded with a punch to defend myself, that would be justifiable self-defense. But if I pulled out a club, or if I pulled out a bat and I started clobbering that person for making that statement to me and punching me, then my reaction and my actions would not be proportionate to the harm that I was facing. And the same analysis would be done in the context of defending others. And the example that we can use tonight is Miss Carey, the 65-year-old Filipino lady in New York who was walking to church and was punched and kicked until she fell to the ground, and the assailant continued to kick her all over her body. And of course, we saw how two individuals stood by at the lobby a few feet away from the incident and watched the attack and did nothing. And of course, they have absolutely no duty to act, right? But a lot of the inquiries that we're getting nowadays is, well, if it happens in front of my eyes, what can I do? How can I stop it? In this scenario, the doorman did not act. In fact, they closed the door and they kind of just turned around and went on did their own, went on to their own business. If they chose to act, however, the rights would be the same as if they were defending themselves. In that scenario, it was reasonable to believe that someone was in imminent danger and immediate harm. I mean, it was happening right in front of them. It was clear that Ms. Carey was being attacked, and that the immediate use of force was necessary to defend Ms. Carey from furthering the attack from the assailant. And as long as they used no more force than was necessary, and they used force that was proportional to the harm that the assailant was doing upon Ms. Carey, they would be acting in justifiable defense of others. So really, it boils down to three things that I want you to keep in mind if you're ever in this situation. The first thing to ask is, are you in imminent danger of suffering bodily injury, or is another person in imminent danger of suffering bodily injury? And the second thing you want to think about is, are you reasonable under the circumstances to use the force that is required, right, to fend off the harm or the threat of harm? And the third thing I want you to think of is your force, whatever force you plan to use, whatever force you plan to use to defend yourself or that other person, that force must be reasonable and proportional, okay? So those are the three key aspects that I do want you to remember in a situation if you're ever caught either witnessing an incident, or if you ever fall victim to an attack. Now, even though there are self-defense laws in place to protect you from criminal liability, obviously there are other ways that you can protect yourself, and I do want to stress that there are other less physical, less without contact, less violent ways to respond. Obviously, we've heard it before. It's known as the 5 Ds: distract, delegate, document, delay, and direct. I didn't make that up, but it's widely discussed and talked about. And also, if you are able to diffuse a situation or walk away, that would obviously be another alternative that I would encourage you to think about in a situation if you're ever caught in that type of situation. And if you can, to the extent that you're able to call for help, or call the police, or call law enforcement, or some authority that's either on the phone or nearby, I would encourage you to do that as well. Obviously, this is the last resort if you're ever caught in that situation. Let's see. And let me wrap up here. I notice I'm almost done with my time, but your rights as a person who's being attacked, or as a witness. Sorry, Mari, you can move on to the next slide. There you go. Your rights don't stop at self-defense laws. If you have been attacked, or if you're a witness to a hate crime or hate incident, or any crime for that matter, the next logical step is hopefully to report it to law enforcement. And once that report is made, under many circumstances, as a victim or as a witness, you have the right to have your information protected from the public. Okay, it will be turned over to the attorneys that are involved in the case and to the court, but you have the right to request that that information be kept private and redacted from any public access. And also, if you make a police report, many of the police agencies are equipped with victim advocates who are stationed at police stations or sheriff stations to give you resources for relocation, for reimbursement, or for any type of psychological counseling that you may need as a result of the incident. And each county in California under law is required to have a victim advocate that is stationed usually at the district attorney's office. And of course, in Los Angeles, one of the largest prosecuting agencies in the country, there are several hundred victim service representatives that assist victims in filling out forms for reimbursement, filling out medical forms, and filling out forms with regards to compensation from the Victim Compensation Board of California. And even if the charges are not filed or brought to court, you are still entitled to a lot of these resources and these benefits. So a lot of times victims will say, or witnesses will say, nothing ever happened. I made the police report, I called the police and I was interviewed, but I was never called to court. It doesn't matter. If you made that report and there is a documented report with your name and information, you are entitled to benefits under Marcy's law and under the victim compensation laws. Let's see. I do want to end on this note. So, you know, unfortunately, the reality is if you are a victim of a hate crime or even a hate incident, you're going to feel alone. You're going to feel alienated. You'll feel isolated and embarrassed. But if anything, after tonight, I do hope that you feel a sense of empowerment, because there are rights and protections of the law that most of you don't know, but hopefully now are equipped with knowing. Thank you.
Thanks, Adrienne. We're going to pass it on to Michael now.
Great, thank you, Adrienne. And it's, can you guys hear me? Yeah. It's always so great to hear from the range of folks working in law and in community-based services. I know this is a really difficult time right now, so I'm going to start my timer, make sure I don't talk too much. I know this is a very challenging time. We're in a current moment that has resulted in a targeting of Asian Americans, and there are many concerns with regard to police excessive force and race and diversity. This conversation here hopefully will provide you with an awareness of some of the tools you have as members of the public to access for your rights. I am in particular a federal government attorney with the U.S. Department of Education's Office for Civil Rights. The Office for Civil Rights is a federal agency that enforces federal regulations that prohibit discrimination on a number of bases. In particular, it prohibits discrimination on the basis of race, color, and national origin, sex, which includes gender, disability, and age. There are 12 offices across the country. Again, these are federal agencies. There's 12 regional offices where we accept and review complaints from members of the public. That means you can go to our website at www.ed.gov and punch in OCR, Office of Civil Rights, and you can electronically file a complaint, and we will review it to determine whether or not we can investigate it based upon an allegation of a violation of your civil rights on those bases I just listed for you. We also do technical assistance. You can call us and ask us for questions. We know some of this stuff is pretty complicated. And we also do proactive types of investigations where we go out and review school districts or universities. So our jurisdiction is of course very important from a government standpoint of federal services and state services. We have jurisdiction over entities that receive federal Department of Education funds. So that is essentially all public schools, kindergarten through 12th grade, all public universities, and almost every single private university. So this is an expansive scope of jurisdiction where federal laws such as, in the context of today, the most relevant, but not the least relevant, is the 1964 Civil Rights Act, which prohibits discrimination on the basis of race, color, and national origin, but also Title IX of the Amendments Act, which prohibits discrimination on the basis of sex, but also Section 504 of the Rehabilitation Act, which prohibits discrimination on the basis of disability, and Title II under the Americans with Disabilities Act, which also prohibits discrimination on the basis of disability. And there's also the Age Act, which prohibits discrimination on the basis of age. These were all passed by the US Congress, and now they're staffed with federal government attorneys to ensure that there is enforcement, implementation of those laws. So with regard to the current moment right now, which is very scary to lots of folks, I understand that. I'm concerned myself. With regard to the concern around hate crimes, in our case, at the US Department of Education's Office for Civil Rights, we don't enforce criminal laws, but we enforce civil laws. The statutes, congressional statutes that I just reviewed with you, are quite powerful. So if you yourself, as a student at a university, or if your child is a student at a kindergarten through 12th grade school, has experienced harassment on the basis of race, color, national origin, sex, disability, or age, then you could file a complaint with our office, and we'll review and we can investigate if we're able to investigate. So each of the 12 offices has regional jurisdiction. In California, we're based in San Francisco, and we review complaints regarding students from schools across the state. There's millions of students in California. It's a big state, so there's a lot of coverage there. In the context of the current environment, I want to start with a couple of things, is that from the federal executive level, there have been some changes, important changes, indicating a top-down, from the White House down, focus on diversity and inclusion and protecting people based upon race and also gender and gender identity through executive orders. Executive orders are laws passed by the president. So for instance, on January 20th, 2021, an executive order was passed on advancing racial equity and support for underserved communities through the federal government. There's a whole bunch of language there. You can see just by that title, it's a shift in approach. Then there is a memorandum on January 26, 2021, condemning and combating racism, xenophobia, and intolerance against Asian Americans and Pacific Islanders in the United States. That's soon after the new administration came in. And there was also a memorandum issued after the Atlanta hate crimes of the 8 persons and the 6 women of Asian descent who were shot. There was also a message sent from the White House condemning that action and memorializing the victims of that. This is from the White House. And finally, another executive order on guaranteeing an educational environment free of discrimination on the basis of sex, including sexual orientation or gender identity. And one more thing, finally, the White House very recently, just last week, named Erica Morisugu as an Asian American and Pacific Islander liaison between the White House and Asian American groups. This will be a very important position to provide transparency between the federal agencies who reach out to Asian Americans, but also nonprofits and members of the Asian American community to ensure that the concerns of the Asian American community are heard. So if you're a member of the public and you have interest in this, make sure to make use of this. One issue that we often have in my office is that there is an underreporting of complaints by Asian Americans, despite there being many, many Asian Americans in the San Francisco Bay Area and in California in general. We want to make sure everybody understands that they have their rights to file these complaints. So a quick review, again, of the type of instances where you might be interested in filing a complaint. Harassment issues based upon race, for example. I have anecdotally heard in school districts of my kids and friends of mine and on the news where in the school context, someone may have said something soon after the pandemic emerged, whether it be on a cyber platform, on a computer platform when they're remote learning, or in person, making inappropriate race-based statements and national origin-based statements about Chinese persons or Asian persons in general as causing the pandemic, or other race-based derogatory language associated with the pandemic. That is inappropriate. And if your child has experienced this, or you yourself have as well, you can file with our office and we'll review to determine whether or not we can investigate. There's also instances of different treatment in general. Like if you believe that you were discriminated against on the basis of race, in grading, for example, or in some other type of access issue to the programs and services of your school, which are all under the scope of federal regulation if they receive federal funds, which again, all public schools do, and including universities, and most private schools receive some form of public U.S. Department of Education funding, and therefore have to comply with federal civil rights laws. There are a range of protections under the protected bases of a race, color, national origin, sex, disability, and age. There's a range of forms of conduct that can fall under those protected bases that could potentially be against the law. And in particular, as an educational entity, with the mission of the U.S. Department of Education's Office of Civil Rights being that we want to robustly ensure equal access to education and promote educational excellence throughout the nation through vigorous enforcement of civil rights. Culture and climate issues are very of concern. And as someone who's also a member of the Asian American Bar Association Civil Rights Committee, my feeling is that education is absolutely at the core of ensuring that we don't have repetition of hostile climate that is discriminatory on the basis of race, and that we work to ensure that our representatives and those around us in government provide a basis to incentivize education that is holistic in a manner that talks about Asian Americans and provides the history of Asian Americans, and also provides a culture and climate as schools and universities, and more broadly speaking in our universities, that recognizes Asian Americans as part of the American social fabric and political fabric. Thank you very much.
Thanks, Michael. I will now pass it on to Brandon.
Hello, everyone. It's a pleasure to be here, and thank you for having the Department of Fair Employment and Housing. It's such an important event. I'm going to go ahead and share my screen. I have a few slides I wanted to just pull up. So one moment here. So first thing I want to say is the Department of Fair Employment and Housing is California's civil rights agency. And we're here to protect you, the people of California, from unlawful discrimination in employment, which I know Bill will talk about, housing, which I will talk about today, public accommodations, which is like a business, and from the perpetration of acts of hate violence and human trafficking. And let me take a moment to say now that the acts of bias-motivated violence and violence against the AAPI community has been extremely disturbing and upsetting. And here at DFEH, we do stand united in calling this deplorable behavior out. And we're here to let you know that we can help, and we enforce the civil law and hopefully can be a resource to you. And I want to talk to you about that today. So I'm just going to quickly walk through the laws we enforce at DFEH, and then I'm going to build into the situation at hand that's been so upsetting for all of us. Today I'm going to talk about the Fair Employment and Housing Act, the housing discrimination part. We do enforce employment law, but our friends at the EEOC will talk about that today. I'm going to talk a little bit about the Unruh Civil Rights Act as well, which protects against discrimination at businesses, which also include housing. So let's talk about it. And then I'm going to talk about the Ralph Act. So the first thing I want to let everyone know is that it's unlawful and illegal to discriminate in any business in California because of someone's protected characteristic, which includes race and national origin, as well as citizenship, as well as a primary language, et cetera. So the first thing is in these examples where we've seen businesses harassing, threatening Asian customers, this is unlawful behavior, right? And I want to let you know that if anyone has experienced discrimination at a restaurant, movie theater, etc., because of who they are, that's unlawful in California, and we here at DFEH will enforce the law. And so that's a real big takeaway I hope that you leave here today, is that no business can shun you, can treat you differently, can harass you, spitting, etc. This is all just awful behavior, and we have jurisdiction to enforce within a business, right? And that's broadly defined. Okay, so I just want to hit that quickly to you. Again, who's liable under UNRUL? It could be a private business, it could be a public entity, and it also includes most housing providers, right? We enforce, and I'll talk about later, fair housing laws. So it's unlawful to discriminate because of where someone's country of origin or their race. This is unlawful behavior. We'll talk more. And remember, for these types of cases, there are damages. We have no criminal law authority at DFEH. We do civil law. But when when you've been a victim of harassment at a business, you can obtain up to $4,000 for each act of discrimination at a minimum. There's out-of-pocket expenses, emotional distress damages, attorney fees and costs. So do know that we enforce the law if there are any businesses that are discriminating or even allowing patrons to become unruly and harass Asian customers is a problem. So do know that we are here for you for this situation. Now, importantly for a discussion today is to talk about the Ralph Civil Rights Act. And what the Ralph Civil Rights Act is all about is everything we've been hearing about. It's about bias-motivated violence, and threats of violence are unlawful in California. So all persons, as the law says, have the right to be free from any violence or intimidation or threats of violence committed against their persons or property because of essentially who they are, the protected class, because they are a member of the AAPI community. That is unlawful. So whether you are actually committing violence, which we have seen in many reports throughout the country, that's unlawful. Or you're threatening violence because someone's a member of the AAPI community, that's unlawful. And know that we have the enforcement ability to take on these cases. And as I told my colleagues, I was extremely worried as soon as COVID-19 hit that there would be bias-motivated violence and threats of violence because of so much of the rhetoric we heard. And I really wanted to move quickly because we have a long history in this country of discrimination against the AAPI community. And we have to stand up against this behavior. And I was reminded of a story when my great-grandfather purchased or deeded his neighbor's house to him because his neighbor, who was Japanese, was going to be taken to the internment camp. And he knew that he would lose his home. And so my great-grandfather took over the property until he returned back from the internment camp. And it's an example to me of our long history of discrimination in this country. And so it's so important that we know that those acts of violence that we're hearing about, threats of violence, whether in the street, by someone in your housing, someone at your employer, wherever it may be, it's unlawful, okay? And the Ralph Act also includes making threats of violence to call law enforcement falsely against someone. So we'd like to know about that as well. And remember, the Ralph Act protects on a whole basis of characteristics, but certainly protects us on the basis of race and national origin, which would protect so much of the violence we've been seeing. And remember, anyone is liable. It's the individual who commits the act, right? And remember, DFEH will investigate. You may not know who committed the act of violence against you, but we will investigate and try to find out. So we have the ability there to help you. And it also, the Ralph Act protects against anyone who's inciting or trying to incite violence against you. So this is a law that really hits at the heart on some level of what we're seeing, especially where it's the threat of violence. And this can be threats of violence, physical assault, cross burnings, bombs, arsons, as we've been seeing, right? Asian churches have been firebombed, religious meetings, and vandalism, of course, which we've been hearing about. But all of this is unlawful. DFEH has jurisdiction here. And we can get restraining orders, punitive damages, attorney fees, all the way down And as well as what's important under the Ralph Act, there can be a $25,000 penalty for this kind of behavior, for violations of the Ralph Act. The court may award that. And then just know that we're always up against this issue of bias-motivated violence and threats of violence versus our First Amendment issue. But do know that while there are some cases we have to work out, I want to encourage you to file complaints, even where you don't know what the issue is, even if you don't know who is the perpetrator. We will try to investigate. That's our job, is to try to find that for you. But I want you to know we're a resource. And lastly, I'll just say this. Everything I've talked about applies in housing. It is unlawful for a landlord to discriminate against you on the basis of your race, your national origin. But I just want to lastly get over to this point, which is, it's not even just about your landlord, right? As I know, and I've been around, what happens when another tenant is harassing you because you're an agent? What do you do? And do know that California fair housing laws require a landlord to correct and end discriminatory housing practices where the housing provider knew or should have known of the conduct and had the power to correct it. What that means, folks, is if you have let your landlord know that someone is committing acts of harassment because of who you are, because of your Asian identity, then that is a problem, and the landlord has a duty to investigate and should take action where they have authority, which could include evicting someone, finding someone in the HOA context, etc. But do know that you are protected against harassment. The landlord has a duty to stop it, even if it's not the landlord or their agent. It's a third-party tenant. So I'm going to go ahead and let you know that we have a lot of resources. I don't have time to go through all of this, but do know you can file complaints with our office, and we are here to help you as best we can. And at this time, we need to stand together and call out these acts of violence and bias-motivated violence. So thank you so much. I'm going to go ahead and stop sharing, and thank you for having me today.
Thanks again, Brandon. Just as a reminder, we do have a Q&A section here on Zoom. So if you have questions, please make sure to type it in there. Our next presenter is Bill Tamayo, and let me just share my screen for his presentation here.
All right, well, thank you so much, Mari, and I want to thank the California Asian Pacific American Bar Association for inviting me to present this evening. This is a very timely panel, given all the attacks that are going on these days. So I work for the Equal Employment Opportunity Commission. I cover Northern California, Northern Nevada, Oregon, Washington, Alaska, Idaho, and Montana, and I direct the investigations and operations. Next slide, please. So under federal law, you have the right to work free from discrimination and harassment. I want people to understand that. You have the right to be free from discrimination and harassment at work. Our laws cover employers who have 15 or more employees, and we represent all the workers who can help workers in those companies, and we don't ask about immigration status, so undocumented workers are clearly covered by the law. The EEOC was established essentially to investigate claims of employment discrimination. We'll go in and interview workers, interview employers, go on site, try to figure out what's going on these different cases, try to work out a settlement with the employer. And if that doesn't work out, we can send it over to our litigation unit, and they can sue employers in federal court. I want to give you an example. In the middle of the slide, the young man in the suit is Cal-APABA. He was a supervisor at Fry's Electronics, and he had very good sales. But one day, the Latina, the young woman to his right, was receiving sexual harassing texts from the assistant manager. Mr. Lamb reported him to Fry's Electronics headquarters, and within a couple of days, he was suspended, and in a couple of weeks, he was fired. And then Ms. Rios was harassed and eventually fired too. So we brought a lawsuit on behalf of both of them. Mr. Lamb, because he was retaliated against for asserting the rights of Ms. Rios, and Ms. Rios because she was sexually harassed. We litigated that case aggressively and reached a settlement for $2.3 million almost 9 years ago. So that's what we do, investigate and try to get relief, some money for victims of discrimination. Next slide, please. So the laws prohibit discrimination on the basis of race, color, sex, which includes sexual orientation, gender identity, pregnancy, national origin, religion, and disability, and age. And we also have a law called the Genetic Information Act, which prohibits employers from disclosing anything about your genetic information or you and your family. And all of these laws will, hopefully cover most of the discrimination that you're going to be subjected to. My friend and co-panelist, Tony Jaramillo, will talk about other statutes, other protections under California law. Next slide, please. So we know that Asian Americans are being targeted. And our concern at the EEOC is that going back to the workforce, the people going back to work may be subject to a lot of harassment. Although Asians are 6.8% of the national population, we're over 8.5% of the healthcare workers, and in California, 26% of the California healthcare workers. And I want to give you a disturbing statistic. Although Filipino nurses are, for example, 4% of the nurses nationwide, they are 30% of the COVID-19 related deaths among medical workers. It's a very sad statistic, but that's what it is. And so we know that there might be harassment and discrimination in healthcare, but also that API workers are going to be impacted in a lot of places where they're essential workers, essential jobs, delivery, cook, grocery stores, and as hotels are opening, many of them are part of the hospitality industry. And so many of them may be subject to some kind of risk. But we also know that there's a lot of harassment, particularly racial harassment, in construction and in warehouses. So these are areas we're definitely looking at. For our chair, Charlotte Burrows, racial justice is a priority, and our commission has passed an important resolution denouncing AAPI hate. So next slide, please. So what we need to know is that it's unlawful for an employer to discriminate on all those bases in hiring, promoting, firing, harassment, and anywhere dealing with all the terms and any conditions of employment. So even referrals, negative job references, because somebody filed a complaint of discrimination, all that would be prohibited. All of that would be prohibited. And so it's important to know you're protected in nearly all of the phases of employment. Now, what we're concerned about, next slide, is next slide, please, Mari. What will it be for Asian workers? And we're very concerned about harassment because we've heard the stories, people saying, oh, you're the Kung flu, you brought the disease here. It's because of people like you that we have this pandemic. Go back to where you came from. And it can also include physical assaults or some graffiti. We have a lot of race cases involving the N-word being put there in place, or things like nooses or actual physical attacks. We are litigating a case right now on behalf of 2 African Americans who worked at a warehouse near Sacramento, whose tires were slashed. They were called the N-word. They were subjected to a lot of harassment. We're litigating all this. So what happens for an employer? An employer has to create creates the conditions of work. They can determine, or they have to make sure that all the workers are safe. And the employer is liable if the harassment comes from a coworker, from a supervisor, or from a third party. So for example, you may be working at a hospital and patients are saying things to you that are racially hostile, like go back to where you came from. I don't want you. You're a Chinese nurse. You're a Chinese doctor. There's no way you're going to operate on me. These kinds of things, where if it's statements by a third party, the employer has to put a stop to that and make sure that stuff never happens. The employee can also take some kind of action against the employer if nothing is done to stop it. Next slide, please. An important part of the law is that the law, aside from it, it says you cannot be discriminated on the basis of race, color, sex, national origin, religion, disability, and age. It also says an employer cannot retaliate against an employee who has opposed the discrimination or reported it, and said that somebody's been harassed and somebody reports it, like Mr. Lamb. They can't be retaliated against for reporting that harassment, or employees who are opposing the discrimination on the job, be it some kind of racial harassment, sexual harassment, etc. They have a right to complain and report these activities either to the employer, also to the EEOC, to the Department of Fair Employment and Housing, because these laws are no good if people fear that if we protest or we complain, we're going to be fired. So employers cannot fire employees or shouldn't fire employees, and it's against the law to fire people, suspend them, cut their hours, transfer them because they engage in what we call protected activity, meaning they oppose discrimination and then they suffered some kind of adverse action there. So unfortunately, despite the Me Too movement and more so-called racial reckoning, our charges of retaliation have jumped tremendously. Before, they used to be about 25 to 30% of the 70 to 80,000 charges a year we get nationwide. They are now in 56% of the charges. So this is a major issue that we're trying to address about retaliation. Next slide. So what happens if you get to the EEOC? Our whole point is to try to stop discrimination, but also to make sure that if the employee has suffered, that they're compensated by the employer. So if you were fired or suspended, you will try to get your back pay, all the pay that you were lost. And then if you have some suffering, a lot comes from harassment. You have a lot of emotional distress, pain and suffering, we get you money. That's called emotional distress damages or compensatory damages. We will try to get you money for that. And then you're also entitled to punitive damages if you can establish that the employer participated or acted with reckless disregard or with malice. And then we try to get other kind of relief, have the harasser fired or have him suspended or have him barred from being rehired, and then make all the supervisors and managers get training so that they know what to do. Next slide, please. So if you are a victim of discrimination, please make sure you contact the EEOC. You have to file a charge with us within 300 days of the last discriminatory act. So for example, if there's a pattern of harassment over a number of months or weeks along the last act happens in the last 300 days, we can pick up all of the discrimination and investigate all of that. In order to get to federal court, you have to file a charge with the EEOC or the DFEH. So we have all our contact information on there. We have office in California. We have offices in San Diego, Fresno, and Los Angeles, and then San Francisco, Oakland, and San Jose. So please do not hesitate to contact us. And again, I want to thank Cal-APABA for inviting the EEOC to participate. Thank you.
Thanks so much, Bill. I will now pass it on to Tony.
Thanks, Mari.
Let me just get your slides ready.
Sure. So as Mari gets my slides up, I just wanted to thank Mari and everyone who put this program together. It's very timely and very important. I'm going to be covering employment law as well, but under state law, and the agency that advocates under the state law is the Department of Fair Employment and Housing. We already heard about that, but I'll come and cover some additional information. Mari, you got it? Okay, so the state law for employment discrimination is very similar to federal law. Next slide. That's what I get for doing fancy slides. So the state law, very similar to federal law, and the law protects you from illegal discrimination based on these very specific categories: race and color, ancestry, national origin, religion, age, disability, and not just physical disability, but mental disability, sex and gender, that's including pregnancy, childbirth, breastfeeding, and related medical conditions related to pregnancy and childbirth, sexual orientation, sexual identity, and gender expression, medical condition, genetic information, marital status, and military or veteran status. One other very important protection that you have under state law, similar to federal, is that you are to be free of retaliation. So if you experience discrimination on the basis of these categories in the workplace, you can report that to your employer. You can report it to the employer, you can report it to the Department of Fair Employment and Housing, to any outside agency, and your employer cannot retaliate against you in the form of firing you, demoting you, transferring you to a very far away location, or anything that is adverse in your employment. Reduce your hours, anything that will affect your employment in a negative way. You're free to be able to report discrimination and not be retaliated against. And in addition, a lot of people wonder, well, what if I'm wrong about the discrimination, that I feel that I am being discriminated against because of my gender and that I'm not being paid properly because I'm a woman, and I report that and I'm wrong. I'm actually being paid appropriately, and then I'm being retaliated against. It doesn't matter if you're wrong. If you have a good faith belief that you are being treated in a discriminatory manner based on these categories, and you report it, the employer, one, has to investigate your complaint, take it seriously, and do a prompt investigation that's unbiased. And you are, the employer is obligated to ensure that you are not retaliated against from co-employees, and of course by the employer themselves. So those are very important things to remember, and to hopefully encourage you to step forward if you feel that you're being targeted and discriminated against, to know that the law protects you if you do report that, and you have remedies. Okay. Also wanted to mention that unlike federal law, the state laws protect and cover employers that are 5 or more. So smaller employers are also part of the what's defined as employer under the Fair Employment and Housing Act. That's the body of law that protects you from workplace discrimination, the state law. And I put in there the phone number for the state agency, the DFEH. For harassment, I wanted to mention that any claims of harassment, the Fair Employment and Housing Act protects you if you have only one, if there's only one employee. Okay, so 5 or more employees for any type of discrimination under state law, 1 or more employees for harassment. Also, similar to federal law, the employer has an obligation and a duty to protect you from harassment by third parties. So a situation such as if you're a waitress or you're a cashier and you get harassed by patrons of the workplace, then the employer has an obligation to protect you. You should report that, and the employer needs to take steps to make sure that that doesn't happen any further again. Next slide. The other body of law that I wanted to cover outside of discrimination based on race, religion, etc., are the right to have fair wages, to have a safe work environment, and whistleblower protections. And that is under the protections of the California Labor Code, and types of claims that are covered there are equal pay regardless of your gender or race, it really does go into discrimination as well, obviously, that regardless of your gender or race, if you're doing the same type of work, same or similar type of work as a male or someone who is non-Asian, you should be getting paid the same. You should be paid timely. You know, an employer cannot just decide to pay you when it makes money or has money to pay you. Payment needs to be timely. You need to be provided with accurate pay stubs that identifies your hours, the hourly rate, and other information that's under the codes that's required. Fair wages also mean that they must meet minimum wage. They must provide, if you're an hourly employee, a non-exempt employee, you must be provided with rest and meal breaks, uninterrupted rest and meal breaks, meaning you're taking a lunch break at your desk, and if the phone rings, you got to answer it. That's not a uninterrupted meal break where you are free from having to perform duties. Also overtime pay, you know, over 8 hours a day, any type of work over 8 hours a day, you are to be paid time and a half, 1.5 times your hourly rate. Safe working conditions, and that also means, you know, when we think about safe working conditions, the employer is obligated to provide that. It's not just making sure that you don't have a staircase that'll collapse on you or that the building is not filled with asbestos, but also safe from harm or attacks or threats of violence. It's situations where you have a workplace where there's patrons that, you know, kind of going back to what I was saying, are verbally attacking or will harm you physically. The employer has an obligation to ensure that your workplace is safe and that doesn't happen, whether that means, you know, lights in the parking lot, making sure that there's locks on the doors after hours, you know, things like that. And again, you're free to be, the employer cannot retaliate against you if you are reporting conditions that are unsafe, or if you're being paid untimely and you report them to the DLSC, you're not to be retaliated against. Also, another thing that is protected and what gives you some rights is right to get your personnel file. I have a lot of cases where they're unsure as to whether or not they're being paid on time or being paid the right rate and so forth, or if they're being written up and they feel that they're being targeted for discrimination and they want to take a look at their personnel file. You have a right to request it. The labor codes provide remedies. If you don't get your personnel file timely, they have 30 days to provide it. If not, there's a penalty. There's a $750 penalty. We've actually tested that code to see if it had some teeth, and yes, it does. We requested personnel files on behalf of our clients. It wasn't provided timely, filed with the labor commissioner, and was able to obtain the penalties for our client. You're also free to speak about your working conditions. So some people don't realize that if you wanted to talk about what's happening to you at work, if you wanted to share about how you're being harassed at work, some employers have confidentiality agreements that they require their employees to sign, but I always cite to the labor code that says that you have a right to speak about it. You have the right to speak about your salary to make sure that you're being paid equally as others, and for that there's no retaliation that employers to impose. I'm going to go over other things under the labor code. There's protections for victims of crime, and I'm going to go over that on my last slide because I wanted to cite the specific labor code regarding that. And also protections to take leave to attend to school matters for a child. So for example, if your child, you get a call from your child's school and you're told that there was some incident that happened, you know, your child was attacked, victimized, what have you, and you need to leave your workplace to go attend to that. You have a right to do that with job protection. An employer cannot, must allow you to do that, and you are not to be demoted or lose your job because you had to attend to a matter related to your child. And it doesn't even have to be an urgent matter. It may even be that you wanted to see your child's Christmas show. I mean, really, these protections are there. California is one of the most protective states when it comes to employment rights, workers' rights. Then again, as long as you give advance notice, you will be able to do that and be able to come back to a job when you return. And there's more. And I just wanted to give homage to Larry Itliong, who is our Filipino American labor organizer, fought for protections. A lot of these protections that he fought for on behalf of the Filipino and Mexican farm workers are reflected in our labor codes. Next slide. Okay, so this is the state agency that has purview over the wage and hour laws that I just spoke about safe work environment, job protection. That's the website. So if there's anything that you experience under the labor code violations of that, this is where you go. Next slide. So I wanted to talk a little bit about what do you do if you feel harassed or discriminated at work. I think first and foremost is you should tell someone, even if it's just for for your mental health, and to share and to let someone know, because it could be very important later on if you do intend to file a complaint with the Department of Fair Employment and Housing, or to file a civil action. Ultimately, it's to tell someone, tell your family member, tell a friend, talk to your therapist, consult with an attorney. You should document the incidents that happened. You know, who was present that could have witnessed that, who was involved in the situation, what date was it, what did you do? Also, discrimination and harassment, it really does have a profound impact on us, on you emotionally. And so seek professional help for any trauma, any assaults, obviously seek professional help. But what do you do in the workplace? I encourage everyone, I spoke about how you're not to be retaliated against if you report harassment in the workplace or discrimination. So report the issue to management, to HR. If it's your manager, your immediate supervisor that's harassing you, go above. And then it should be in writing. The employer has an obligation to investigate, which you should cooperate with. There's resources, there's frequently asked questions on the DFEH website, consult with an employment attorney, and then file a complaint with the Department of Fair Employment and Housing, because you have to do that to invoke the laws to protect you. And what's different about state law and filing with the DFEH is the statute of limitation. You have 3 years, much longer than the 300 days to file with the EOC. You have 3 years to file from the last act of discrimination and harassment if it happened in 2019, because that law had changed. It was originally 1 year, but as of 2020, it's now 3 years. So anything that happened within, in 2019, you have 3 years to file. But there's also what's called continuing violations. So if there's things that happen like for many years, as long as it's continuing and the last act happened within 3 years, you can file. And the DFEH, as we know, will investigate or give you what's called a right to sue letter, in which then you can get legal counsel and file a lawsuit. And you have 1 year to do that from the date of the right to sue letter. Okay, next slide. Okay, what if the issue is not being paid your full wages and other labor code violations? What should you do? You should always keep copies of your time records. And some employers are just bad at it, and they don't, they don't keep time records, or even though they're obligated to, or they don't have you do timesheets, but you kind of go in and out, and you're being paid a salary when in fact you should be getting an hourly rate. So keep records of your timesheets, schedules, pay stubs, copies of job description and your duties, or make note of what your duties are. Sometimes you're given a job title and you're being paid on a salary base. And in fact, your duties are one that would require them to pay you hourly and pay you overtime. So those are some of the reasons why you want to keep your job description and keep note of what your job duties are. Again, report the issue to management in writing, get a copy of your personnel file, and then there's these frequently asked questions, other resources out there on the DLSE website. I have that on my prior slide. Consult with the labor employment attorney, and the time deadlines are listed there as to how long you have to file. But don't delay. I mean, you obviously want to file as soon as you can. Next slide. I wanted to highlight some labor code statutes that will protect victims of crime. Labor Code 230 and 230.1. If you're a victim of crime, or you're a person, a person who has an immediate family member who died because of a crime, you have a right to take time off, to take a leave of absence, and the employer cannot fire you or discriminate or retaliate against you because you had to do so by virtue of the fact that you're a victim of a crime or abuse. So what I would suggest, though, what the codes require is that you give your employer advance notice of your anticipated absence, and then provide documentation. And so the types of absences that are protected are things such as you have to meet with the district attorney because they are prosecuting the case, and you have to testify in court because you are the victim of that crime. Or if you are a victim of stalking or other types of or domestic violence or a crime of physical injury or mental injury, you can take time off to meet with a victim's advocate, take time off to seek mental help, or go to a shelter. So those are all under Labor Code 230 and 230.1. And also, I'm not an immigration lawyer, but my understanding too, if you're undocumented, there's a U visa that can be applied for to give you a right to stay in the US if you are going to be assisting law enforcement in prosecuting a crime, if you're a victim of a crime. And I think that's all I have.
Thanks so much, Tony. And now we're going to go into our live Q&A section of our panel. So if I can invite all the panelists to come back on, and let me stop sharing my screen here. So there's been a lot of activity in the Q&A section. I know some of our panelists already started asking some of the questions. The first question I do want to ask, though, is not here, but just wanted to see if Adrienne is back, or maybe other folks can also answer, what is the difference between a hate crime and a hate incident? Just because I know that's a common question that folks have. Maybe Adrienne, you can kick us off.
Sure, I can comment on that. Hate crime basically is just words. For example, the best way to explain it is through example. If someone came up to me and said, go back to where you came from, where you Chinese kung flu, whatever derogatory context it is, those words alone are not a crime. That would essentially be classified as a hate incident if you reported that to law enforcement. But if that statement was coupled with either a threat of violence or actual violence, or a destruction to property, so you have that statement plus an action, that would be considered a hate crime. I hope that clarifies it.
Yeah.
In either event, I do want to stress that, at least in LA, I can speak from experience in Los Angeles County and LA City, those incidents would be documented by LAPD or the Sheriff's Department or any other law enforcement agency, even though they don't rise to the level of a crime. And the reason why they document that is because a lot of times those prior incidents can be used in future prosecutions if that person or that assailant commits another crime in the future. We can look back and run his name and run his rap sheet to see if there are any other prior incidents of hate that can be used to prosecute him in a current case. So they are important. We do take those, law enforcement does take those seriously, even though they don't rise to the level of crime.
Can I add something?
Yeah, absolutely.
If it's in the context of employment, so if someone said, go back to your own country, you kung flu, and that was said to you by a co-employee or a supervisor or even a patron, that may be incidents and evidence of, and that could give rise to a harassment claim in the employment context, which is civil remedies, not criminal, obviously.
Thanks, Tony. Does anyone else want to add to that?
Well, I would just add, under the Ralph Civil Rights Act, that, you know, when we talk about there being hate crimes, like a criminal act, you know, that certainly is there. But I would also let you know that even though they're a hate crime, under our Ralph Civil Rights Act, there is also liability for threats of violence or actual violence. So while we're thinking about hate crimes and, you know, going to the district attorney, do know that there's also a civil law that would protect against like incidents that may not even necessarily be a criminal act, but could have been a threat of violence or something else, an incident. And that's why I say, let us investigate, go ahead and file. You don't have to determine, you know, if the police are not taking the case or what have you. Please feel free to file that with DFEH. Let us investigate. Err on the side of caution. Let us try to help you because that's what the Ralph Act's for.
Can I just add something to Mari? So I want to just add on to Tony's point about harassment. So harassment, you know, generally sometimes it could just be words that are what we call severe or pervasive. It floods the workplace, but it could also escalate from words to physical acts like, or, you know, grabbing, touching, all the way up to rape and sexual harassment, or beatings, like in some of our racial harassment case or national origin cases, we've had to litigate across the country, or like in the case we're litigating out of Sacramento, where their tires are, these two Black workers' tires are slashed. They've been targeted with red laser dots, like they're going to be killed in the warehouse. So these are the kind of cases that we're talking about, but it can run the gamut from words all the way to physical acts and graffiti.
Thanks so much for that. Those are great distinctions, by the way, that, you know, there are remedies that you can pursue outside of the criminal options, right? So thanks everyone for chiming in on that. Since we do have a lot of government agencies here represented, are there other, does the DFEH EEOC have, and maybe even the U.S. Department of Education, have any training events offered to the public to enhance what everyone shared so far?
I can just speak for the EEOC. We're doing panels all around the country now, but if you need more, if you want specific training for your organization, for your company, we're more than happy to provide that. Just contact us. You can contact Linda Lee. She's our outreach and education coordinator at linda.lee, L-I, at eeoc.gov. And she'll work with you to organize the training. Thank you, Linda, for putting your email in the chat.
Anyone else with information on other trainings?
Yeah, this is Mike. You know, part of what the Office of Civil Rights at the U.S. Department of Education does is provide technical assistance. And that can come in the form of, we have open lines you can call in if you like. And I'll put the number over here. It's by region. And there will be an attorney or an investigator available to answer questions. In addition, if you need like a panel training or just a call with a group of folks at your school, for example, at a recipient, we do those all the time as well. You can reach out to us too. I'll put my email in there also. Thank you.
Yeah, and I'll just add, of course, you know, just like our colleagues at the Department of Education and EEOC, we're more than happy at DFEH to do any kind of training that within our jurisdiction. And certainly on the housing front, issues around there, more than happy to join in. And I know we always are joining with Bill and EEOC throughout the country on all the panels. So more than happy to help, and I'll go ahead and chat my email as well.
Thank you. I also want to flag the resources that Christina dropped in the chat earlier. Christina, maybe you can drop it in again. So the materials that we are providing are also going to be translated, and Christina will drop that in again in case you missed it earlier. Another great question is actually from Linda. What can we do to encourage more AAPIs to report hate crimes and discrimination? Does it go beyond simply knowing your rights? Do we need more other forms of support or education? What are the biggest obstacles to AAPIs coming forward and asserting their rights? There's a lot of questions in there, but maybe some of you can provide some suggestions.
I think more programs like this, I think getting the word out and just having more programs like this to encourage them. I think a lot of it too is, perhaps some of it is we're expected as Asians to respect authority, remain quiet, not make, noise. And I think that, I think talking about that and just discussing and having, roundtables and discussions like these to help encourage the community to come forward, to let them know that the laws protect you if you're going to file a complaint or to file a report, that there's laws that will protect you. So getting the word out, education, and continuing these types of programs, I think is important.
And I would just add, just to let people know again that you don't have to be a lawyer or have to figure out if this is a violation or anything like that. Just know that if you feel that you were discriminated against in employment, housing, a business, or someone in the public was harassing you on the basis of who you are, you go ahead and file the complaint. That's what we're here for. We will investigate. We will help you. So know that you don't have to have this. I have a lawyer and all these documents and I have a whole case. Just go ahead and let us know because we may be able to help you even with just what limited information you may have, especially if it's some type of attack or incident that happened in public. We may be able to help. So just know that, just come forward with the complaint. It can help. You don't need a lawyer or anything like that.
So I know that many people are scared right now. That's why they're not reporting. Or they have been laid off during COVID-19, or their spouse or partner or other people in their household have lost their jobs during COVID-19. And so they're not about to complain about words, maybe. And so that's a big problem that we're going to have to address. But I think the benefit is that our respective agencies want to help. I'm calling also out to the advocacy community, because oftentimes you will be our eyes and ears in many of these communities where we don't have a real presence. And please work with us to bring a lot of our cases. I will tell you, for an office, that we filed a lot of cases for farm workers who had been raped. And many people will say, well, how did they ever get to you? Well, they weren't coming to our office for years, even though this stuff had been going on. But it was really our painstaking efforts to say, please bring the issues to us, and then working with groups like California Rural Legal Assistance, United Farm Workers, Líderes Campesinas, and then starting to file cases that people understood then they had rights and that there was a place to go. And we have to kind of create that culture within the Asian American community that you have rights, you have a place to go, there are remedies available to you. We understand there's a fear of retaliation, but the law also protects you against retaliation. And I would have to say, I acknowledge that all the people who have come to the EEOC, Asians, Latinos, African Americans, women, Arab Americans, etc., they have been brave. They have been very brave to come forward and tell us their story. And I should tell you, during our investigation, everything is confidential. We can neither confirm or deny the existence of any investigation going on to the public. The only people who will know about it is obviously the employer, because we're investigating the employer, and the employees who are involved or who are possible witnesses or anybody who is a witness to the case. Otherwise, we don't discuss it publicly. If we file a lawsuit, then it's very public because it's all in court. We issue press releases about it and so forth. But I really want to encourage people to come forward. All of our agencies and groups are part of this effort.
I want to note on top of the retaliation protections that also my agency and federal agencies in general have as protections, akin to whistleblower protections for inspector general offices for political misdeeds or abuse of ethics laws and fraud. Also, there are some concerns, I think, folks are largely or proportionately immigrant. We don't take information on your legal status in terms of citizenship. It's not even relevant. Sometimes that comes up as a concern. It's not relevant to whether or not you've been discriminated against. We don't ask for that information at all. So that's not a factor in the process.
That's a really good kind of segue to the other question about, will the immigration status of undocumented people become a problem when they report hate crimes or incidents to the police, DFEH, and other government agencies? I think it's worth expanding on that and just letting folks know that it's not going to be a problem. Brandon, you were shaking your head.
Yeah, absolutely right. It's not a problem. As Bill said, we're not releasing that information. So certainly, absolutely not a problem. And I would also say, in addition to other folks here on this call, that the department can certify here, DFEH can certify UNT visas for folks who are, assisting or have been victims of this type of bias-motivated violence, et cetera. So we're here to help, right? So we certainly want to let you know that it's not an issue, and in fact, it could end up being a reason for maybe a certain type of visa protection to allow you to assist in a case, remain here in the United States. So absolutely not an issue. And, and I would just, to pick up on the other point, we just reiterate that, there's been so much systemic discrimination in the Asian community, against the Asian community, that we know why it's hard to come out to these things, and whether it be immigration status or just you've been through so much in your life that you want to move forward. As I see Linda chiming in, I would just point out that it really is about speaking up and trying to help other generations and other folks, and certainly your status here is not an issue, and we hope you can come forward.
So I want to add that employers are using immigration status sometimes, and if they threaten to say you complain about discrimination, they say, well, Maria, if you come forward and complain, I'm going to have you deported. I'm going to have your brother fired who's working here at the company and deported. That is retaliation. So that is a violation of civil rights law. If they threaten you with deportation, you can, that's a violation because it's trying to stop you from asserting your rights. And then for the EEOC, we don't ask immigration status. Don't tell us your immigration status. It's not necessary for us because it's relevant to whether you were discriminated against or not. However, when we get into, and just like the DFEH, we are one of the agencies listed in the federal regulations that specifically say we can certify for a U visa that allows somebody who's cooperating with the EEOC or law enforcement to stay in the country while we're investigating the case. Eventually they stay for 3 years and they can adjust to lawful permanent resident status. As the EEOC regional attorney, I've signed several of these certifications. But also when we were in a litigation, in a lawsuit, and sometimes the employers start to ask questions about immigration status, we run to the court, and 99% of the time we're successful in getting the federal judge to block any questions about immigration status from ever coming forward, and not letting the employer talk about it, never letting any of that information into any kind of hearing or trial. So we've had years and years of litigating these immigrant worker cases, so we've had to fight these battles a lot of times. So please, I hope, if you have any questions about immigration status, contact me, contact the regional attorney, Roberta Steele, and we can work with you on those issues.
That's
I
true
used to
too.
practice immigration law, so.
I was going to mention that's true too when you file a private civil action. So even, outside, once you're done working with the EOC or the DFEH and you decide to go forward with the civil action, those information is protected. They can't retaliate against you. In fact, lawyers have the other side, lawyers who make those threats and try to inquire into immigration status or information like your driver's license and your social security and things like that, always don't have to provide that because it would lead into immigration status, and they're not entitled to that.
And likewise, in the criminal context, in my experience, I've never asked a victim or a witness his or her immigration status, and law enforcement never asks that question. Obviously, like Bill and Brandon said earlier, all law enforcement agencies, including city attorneys and district attorneys, they are able to certify U visa applications and witness T visa and S visa applications as well. So they are very helpful in that regard, and they will facilitate whatever needs to be done as long as you are cooperative with law enforcement and in the prosecution of the case.
Thanks, everyone. I think this is really helpful information because as the other questions are coming in, it sounds like, it's really difficult for clients to report hate crimes or incidents like that, especially when they don't necessarily speak English. One of the questions is there a way around the requirement of asserting some kind of racial bias? And also, are the agencies able to take complaints in other languages other than English? Brendan?
Yeah, for DFEH, any language, we have the ability, I know, same with our colleagues, to take any kind of communication via phone or in writing in any language. So everyone is welcome in any language to file or reach out to us. So certainly that's not a barrier. Yeah.
At least for the EEOC, we have access to all kinds of translators, and some of our staff are bilingual. We may not have all the dialects of a particular country, but we'll try to get somebody to help you out.
We're the same circumstance at Department of Ed. We have folks who are bilingual, and also we have services that we utilize when someone needs interpreter or translation services. Thanks.
Someone also left a comment in the chat that it's probably helpful if there are success stories that are similar to other folks' hate experience that we can share. Any recent success stories in related to hate crimes or hate incidents or cases of discrimination that y'all can share today?
I can share. I mean, we haven't had any significant spike yet in Asian hate crime cases, and I think it's still early. I think it's going to be, as people more and more go back to work, we hope these stories will come out and people coming. But I want to share with you that shortly after George Floyd was killed, and we were right in the middle of litigation against a company that was a construction company that was part of the people building the Apple spaceship campus, and it was on behalf of 4 African-American men who had been subjected to a long period of racial harassment, nooses, the N-word, constant threats, etc. Well, shortly after George Floyd died, we got into settlement negotiations with the company, and we settled that case for $1.25 million. But unfortunately, just about next month, we're filing a big racial harassment case against the Packaging Corporation of America near Sacramento for similar and even probably more violent racial harassment. So it's going on, but it's part of the battle. But yeah, we've at least EEOC, we've recovered millions and millions of dollars for victims of racial harassment, national origin harassment, and certainly for sexual harassment.
Yeah, just to kind of repeat, Bill, I mean, there's certainly, maybe don't have a specific case in relationship to what we've seen in the media and things and the street violence that's been occurring against the AAPI community as of late. But certainly there are plenty of success stories of folks coming forward and being able to give relief. And just to kind of piggyback on the last question, folks are saying, do you have to, plead out or say racial discrimination? Not at all. I mean, don't worry. I mean, anything, just tell us your story. And that's where we're here to help you. You don't have to, oh, it was this, was it that? Just let us know what happened and know that we're here to help. And you don't have to be a lawyer or, know this lingo that we're talking about. You just have to say, hey, this is what happened, and we'll help, and we'll be able to refer to our colleagues here and get you in the right place or at our agency. But yes, there is lots of success. And I'll also throw out too that there's also a process of mediation at DFEH where that just to let people know that it's not always like a long trial and years and years. There's an opportunity, and as well as with our federal counterparts, to mediate cases, conciliate cases. So there's options outside of a long road where you may be able to get relief.
At least, let me touch the criminal context. At least in Los Angeles, a few months ago, there was a move from one of the prosecuting agencies here to not file hate crime allegations. And obviously, that would have a severe impact, especially on the AAPI communities. That move has been blocked. So the agency is still continuing to file hate crime allegations as long as the facts support those allegations.
So in terms of the resolutions with the Department of Ed, which are administrative in nature, they typically are remedies where the university or the school district, number one, there's a number of individual remedies if there's specific discrimination, let's say on the basis of harassment or different treatment. Could be like correction of an expulsion or say like grade, different treatment. You could have compensatory education for lost education. Tuition could be recompensed for lost tuition. But there's also systemic stuff, which I think is really important to remember, the systemic and cultural aspects with what's going on in schools and in society. With schools, that's a really important place for students and young people to learn from each other and learn how to work with each other in an empathetic and inclusive manner. So we often have a range of cultural competency for not just the students, but the adults too, because oftentimes the adults are the problem as well, meaning the administrators and the teachers, et cetera. But it's those systemic type of, to me, remedies are the most effective so that you can put in place policies and procedures across in an institution, and hopefully from one generation to the next, they will maintain that and incentivize that new kind of cultural norm, so to speak.
I think we've answered all of the questions, but I do want to hear from the panelists as well. There was a comment about folks being concerned about the time and energy and balancing the pros and cons of speaking out. So I wanted to hear from the panelists, maybe words of encouragement to everyone who's in attendance today, why it's important to speak out, why it's important to file a complaint, with anti-Asian hate sentiment rising. Share with us your thoughts on why everyone should report hate crimes or hate incidents.
I think that, we need to stay and remain in solidarity. I think also we just finished the Floyd trial, and we saw courageous people in the beginning, if you follow the trial, who stepped forward, the courageous young girl who videotaped the crime happening, the bystanders who said, stop, don't, you're killing him, he can't breathe. And they all took time and took the courage and came forward, and they're heroes. They helped change, the direction of how how this pivotal moment in our time play out. And I think that, we should all remember that, it does take time and takes courage, but, there's a greater good that's going to come of it, and that we need to stay strong and stay together, and to know that we have each other to support each other if we do come forward, and there's laws that protect you. There's people that will stand by you and be there for you, you know, to help you, you know, have the courage to come forward.
Let me just, oh, sorry. Go ahead.
Okay, thanks, Adrian. So I would just add, it takes a lot of courage, and virtually all of our harassment lawsuits, be it sex, race, national origin, they don't come to us as harassment cases. They come to us after they've been fired, and then workers feel like, okay, I got nothing to lose. So I know they put up with a lot before, including rape, before they come forward to complain. But fortunately, you know, as more and more people come forward and tell their story, it gives courage to others to come forward to complain. And I would say, if, you know, we need to come forward and help each other, because if we don't, the racists, those who believe in hate, they continue to win. And they haven't gone away. They're aggressively on their agenda. And so we have to be just as willing to come forward and say, you know, what our problems is. And you have federal government agencies, state government agencies that will do the work to investigate for you. You don't have to, as Brandon said, you don't have to come up with everything. That's our job, is to investigate. You're like giving us a tip about a violation, and then it's our job to go seek it out and try to find the facts.
At least from the victim survivor front, the only thing I can really stress is that you're not alone, right? You're not alone in any stage of the criminal case. You won't be alone from the time that you report it up until the time the case is concluded. You will have victim resources available for you from the DA's office. The courts have resources that are available to you. It's just a matter of being aware of what exactly those resources are and taking advantage of those resources. And I'll say, you know, from personal experience, I would be happy to accompany a victim of a hate crime and sit at a police station for hours, which we have done, just to make sure that a report has been taken. I mean, my wife was at a police station for 6 hours waiting with a Japanese American individual who was a victim of a racial attack. And those are the things that I encourage other attorneys to do. I see we have other attorneys that are participating and watching. That's something that we can do as attorneys. I mean, we are empowered with our degree and our experience. And I encourage everybody just to kind of just take that one step and offer whatever services that you can, so the victims know and witnesses know that they are not alone in this fight.
And I would just add, you know, I think all of us, you know, understand that this is hard. And, you know, in my experience, you know, someone shouting the N-word at me or things like this, sometimes it's hard to want to fight every fight and having the energy. So I understand that, because the AAPI community, like other communities, is subject to so much systemic racism and discrimination, that sometimes it can feel like just, you know, that's what it is. And I think all of us here are saying that we understand that, but it's an opportunity to stand up. We need reconciliation. We need healing. And it doesn't start until we take a stand and say, you know, this is out of control. And there are agencies here that are gonna help. And we all need to create a movement of support. So while I understand how hard it can be, having been, you know, everyone's been the victim of so much discrimination and shunning and spitting and yelling and violence, but we have to start somewhere. And there's an opportunity, there's an opening to really try to create more equity in this issue. And I hope we can all come together and make an impact with this window that's been put forth and the attention that is so needed on this subject.
And it just following from Brandon and Bill and Tony and Adrian, that the value of standing up and making a complaint. It's not just about your own individual circumstance. If you look at historically, the response of the Asian American community of Vincent Chin's, that was a hate crime back in the 1980s that a lot of younger people do not remember anymore. But in academic circles, we're trying to educate students about this, to the Atlanta murders. There's a big difference between the response back in 1982 to 2021. stemming from the executive on down and from allies. It's because of the many, many decades of activism by Asian Americans and their allies to educate each other about the importance of understanding histories and the importance of understanding rights, so that each time there's a spike, that we have at least some type of baseline to work from of nonprofit groups and folks in media and also in law and in nonprofits all across the board. There is so much, actually, a lot of content now tied to the pandemic that you can find online at YouTube and elsewhere by Asian Americans and allies on the concerns with the pandemic, targeting of Asian Americans and the hate crimes. That is very different from back in 1982. And that is because of people standing up and making complaints. So there's absolutely an important systemic aspect to this that changes and improves the culture. But again, I think it's really important to ground that in that allyship that has been really practiced in this last year. Thanks.
Thanks so much, everyone. Thank you to our wonderful panelists today for sharing your subject matter expertise with us and, educating everyone here today on our rights and the places where we can complain, and really encouraging all of us to stand up. Charles, do you want to close it out for us?
Yes, absolutely. And I want to just express my deep appreciation. I feel like each of you has given us a gift tonight, really and truly. And thank you so much for our amazing panelists, Adrian and Brandon and Bill, Michael, Tony. This is really a labor of love. So thank you for what each of you does for our community. Mari, you're such a superstar. Thank you for your expert moderation. And what I'm going to do right now is I'm going to drop in the chat a link to a playlist. As soon as I get a copy of this video from Brandon, I'm going to add that to the playlist so you can see a copy of the slides and replay some of this information. I know there's been a lot of information here, and I just want to point out call out a few folks here for special praise. One to APILO, API Legal Outreach, and I really want to thank Monica Lebowski. She's been such a wonderful thought partner, and Dean Ito Taylor for his leadership, ABA Bay Area for coming up with this idea. And I want to give special thanks to Christina Chen of the Morgan Lewis Law Firm. She really has filled in the gaps. I mean, she's been kind of the glue. I haven't put together a panel before with 4 or 5 simultaneous interpretations, and this one was not easy. And I admire so much, the efforts of Christina and her team, and special appreciation to our interpreters who have been working hard for the last nearly 2 hours here. So with this, we will bring the APAs versus Hate Conference to a close, and thank you so much.